Okay, we're at
This
agenda
meeting
item
is
12.
being recorded.
We're at agenda item 12, Enforcement and Compound Committee. I will now turn the floor over to Maria Serpa, Chairperson for the Enforcement and Compound Committee. Maria, please go ahead.
Thank you, President Lippy. Did you want to take a roll call first?
Great idea. Okay. Let's start with Sung.
I'm here. Right.
Thank you. Ricardo? Ricardo? You on mute? All right, I'll go to, well, I know Maria's here. How about Albert? I know you're here.
I'm here.
Yeah, okay. Jason?
Here.
Thank you. Jig?
Here.
Thank you. Debbie's not back yet. Shirley?
Here.
Thank you. Ryan?
I'm here.
Thank you. Cheryl?
Here.
Thank you. Has Ricardo come back? Okay, well, we have a quorum, so Maria, let's go ahead. Thank you.
Great. Thank you. Members, I would like to draw your attention to the Enforcement and Compounding Committee's report and attachments from our meeting yesterday on October 27th. Looking at the first item labeled A, discussion and consideration of recently signed legislation impacting the practice of pharmacy. The committee reviewed recently signed legislation and discussed implementation recommendations. I ask that the board consider all the legislation listed in the committee report all at once at the end of my presentation here. I will review each briefly and will be able to take questions and comments at the end if that's okay. So, because we have quite a few to review. So the first one to review is, the order on the screen is a little bit different. We're starting with AA, which is AB 1710. Thank you. This measure provides pharmacists with the authority to independently order and administer FDA authorized or approved COVID-19 vaccines. Before I continue, I think if someone could put their phone or their computer on mute, we're hearing a lot of background. Thank you. As indicated in the meeting materials, we had a support position on this bill. Although the meeting materials indicate that the implementation should be straightforward, I want to acknowledge the recent immunization alert that was released by the board. For that reason, I'll be a little bit more detailed on this one issue. As indicated in the email alert that was recently sent, the board strongly encourages pharmacies, designated pharmacists in charge, and pharmacists to evaluate their practices of initiating and administering vaccinations and take immediate corrective action to ensure that their practice apply with regulations. It is my understanding that a number of inquiries have been submitted via the Ask Inspector line and to staff directly requesting that the board evaluate scenarios to determine compliance. Such an assessment must be done on a case-by-case basis by the pharmacy and its staff. I will note that it is my understanding that there is a wide range of processes being used. We would suggest that if you are unclear if your current process complies with the law, that you consult with an attorney. Further, should it be helpful, these are a few questions that you may want to consider in assessing your operations. Number one, who is writing the order for immunization and directly ordering in the pharmacy system? Number two, who is interacting with the patient regarding their health, allergy, and other information? Number three, what functions are currently being performed by non-pharmacist staff, and do such functions require judgment? Number four, to what extent is the pharmacist involved in the system process? Regarding AB 1710, staff will undertake early education on the measure to ensure that pharmacists are well positioned to begin initiating and administering COVID-19 vaccines on January 1. assuming there is an FDA-approved or authorized vaccine available. The second one is AB 2077. This measure extends provisions for needle exchange programs and provides that such a condition of furnishing a pharmacy must provide information on access to treatment, access to testing information, and information on safely disposing sharps waste. Staff will include this information in the webinar Pharmacy Law 2021 and in the script. The third item we reviewed was AB 2113, which requires the board to expedite applications for an applicant who supplies satisfactory evidence to the board that the applicant is a refugee, been granted political asylum, or possesses a special immigrant visa. Staff will need to make changes to some forms to implement, and they plan on developing an FAQ to provide guidance to applicants. As implementation evolves, it may be necessary in the future to promulgate regulation. Next page is AB 3330. Of note, the board did not discuss AB 3330, but this measure increases the cures fee that licensees pay to the cure system operated by the DOJ. Staff will send out reminders as the implementation date gets closer. SB 878 requires the board to post its application and renewal processing times. This is already included in the licensing committee report to the board. And then lastly, we have SB 1474, which extends our sunset date for 1 year. The executive officer will be providing an update on the sunset process today during her report. The committee has no motion for this section, but we do have an opportunity for member comment and then public comment on the legislation presented. Members, do you have any comment?
Maria, I just wanted to, this is Ricardo Sanchez. Just want to say I'm here. I was like 5 minutes after you started. Sorry about that.
Thanks, Ricardo. Do you have any member comment on the legislation? Thank you. I think we're ready for public comment.
This is the moderator. I have opened the Q&A session for public comment. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen. Type "I would like to make a comment" into the ask field and submit that to all panelists. I will pause for a moment to allow submission. Seeing no requests, would you like me to close the panel?
Please do. Thank you. We'll move on to item B. Sorry, I cut you off. Item B is discussion and consideration of compounding animal drugs from bulk substances, including federal law and the FDA's draft guidance. The committee had a very robust discussion on this issue, which included public comments. This is a complicated issue regarding federal law and the FDA draft guidance on the issue of compounding from bulk drug substances for animals. The details of these are included in the meeting materials. The Food and Drug and Cosmetics Act provides specific conditions under which extra labeling use from compounding of approved animal drugs or approved human drugs is permitted. The extra label drug use regulation does not permit animal drug compounding from active pharmaceutical ingredients or bulk drugs. This is the current law. However, the FDA is working on draft guidance to continue to exercise enforcement discretion under the circumstances when no other medically appropriate treatment options exist. Although still in its draft form, the draft guidance provides conditions under which the FDA states that it will generally exercise enforcement discretion. The agency may take action when animal drugs are compounded from bulk drug substances that do not meet certain criteria. But they do intend to defer to state licensing boards the day-to-day oversight. And for brevity, I didn't go through all the details, but it is in the meeting materials. We have heard from members of the public of a concern on how the board is enforcing this provision and the confusion regarding the draft guidance. We also heard from members of the public that they disagree with the FDA. Ms. Sodergren shared that inspectors are evaluating each situation on a case-by-case basis and are providing education on these issues during their inspections. Earlier this year, the board received information about compounding by California pharmacies using bulk substances rather than sourced from the FDA-approved drugs as required by the Food, Drug, and Cosmetic Act. In addition, the board received information that pharmacies may be compounding from bulk substances instead of from commercially available products, purportedly to reduce costs. The committee also heard comments from DCA counsel Eileen Smiley, who provided legal guidance to assist us in understanding the responsibilities of the board. Both Ms. Sodergren and Ms. Smiley are present on the call today should the board members have any questions for them. After a lively discussion, the committee took no action, but put before the board the following. So what we're asking for is staff to continue to monitor the issue at the federal level and to inform the committee of any updates. Also, staff will continue to educate licensees and monitor for compliance while balancing enforcement discretion and assessment of the individual case-by-case basis. Members, are there any comments? And as I stated, both Ms. Sodergren and Ms. Smiley are on the call with us should you have any specific questions for them. Well, maybe everyone's talked out because yesterday we talked for a few hours. Hearing no member comment, making sure we are ready for public comment.
This is the moderator. I've opened the Q&A panel for submission of requests for public comment. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen. Enter "I would like to make a comment" in the Ask field and submit that to all panelists. Our first comment is from Daniel Martinez. Danny, your line is open. You have 2 minutes.
Thank you. Danny Martinez with the California Pharmacists Association. For those of you that did receive our letter on the board, you'll notice that we did ask for this item to be agendized. We, as I mentioned yesterday during the committee meeting, we are very, very concerned about the practical effects of this action by the board. The fact that the FDA has a draft guidance, this is, by the way, the second draft guidance. There was one earlier that was in process and was pulled back. The fact that there is a guidance in place by default means that the FDA recognizes that there are instances where compounding from bulk drug substances is appropriate and medically necessary. For the board inspectors to start issuing orders of correction, which by themselves I recognize are not discipline, but can lead to disciplinary action, is essentially a way to say that the pharmacist is doing something wrong, when in fact that is not the case. As I've mentioned, and I'm not going to go into the letter, I don't have time in my 2 minutes, but just the highlights that I hit yesterday, and mainly what the big issue is that if pharmacists are forced to compound using only commercially available products, there are fillers and binders within those commercially available products that are toxic to animals. There are various examples through our letter, through other letters that you guys have received. And I would ask this board to really reconsider this action by board inspectors. The fact of the matter is, while these orders of correction, again, are not discipline, they serve as a de facto ban on a practice. through these warnings. And so I would ask that this board consider having these inspectors pull back on that
10 seconds.
in the name of patient safety. And I'm here to answer any questions if you have any questions about our letter. Thank you.
Our next comment comes from the California Veterinary Medical Association. Your line is open. You have 2 minutes.
Good afternoon, everyone. My name is Dan Baxter, and I'm the incoming executive director for the California Veterinary Medical Association. The CVMA submitted a letter on this subject last week. I hope you've had the opportunity to review that. It's at item 12B of your supplemental board materials. We also offered comment on the CVMA's behalf during yesterday's enforcement committee meeting. I know several of the board members here are on that committee, so I'm not going to rehash the comments that we made yesterday today. The CVMA appreciates the thoughtful discussion that the committee had yesterday and the committee's recognition that this is a complicated issue that is changing quickly, due in part by actions taken by the Food and Drug Administration. The only item that I want to reemphasize this morning is that the compounding of animal drugs from bulk substances is sometimes the only mechanism through which vital medications can be obtained. We ask that this reality be kept in mind during the educational process by Board of Pharmacy inspectors so as to avoid the transmission of a message that could even unintentionally result in animals not receiving the medications they need. Also, we want to note that we do not disagree with the FDA. We disagree with any interpretation of the federal regulation that would somehow prohibit the compounding of bulk substances in a veterinary application. So we want to clarify that in regards to comments that were made just a moment ago by the presenter. This issue is obviously a high priority for the CVMA, and we really value the board's time and consideration. We're committed to maintaining an open dialogue with the board, and we're available for further discussion. Thanks a lot for your consideration.
Thank you.
At this time, we do not have any additional requests for comment. Would you like me to close the Q&A panel?
Please do.
It is closed.
Thank you. So members, what we're asking for is board approval of the committee suggestions to the staff. And those, just to repeat, are to have instructing staff to continue to monitor the issue at a federal level and to inform the committee of any updates. Staff will continue to educate licensees and monitor compliance while balancing enforcement discretion and assessment of individual case-by-case basis. Mr. President, I think we're ready for a vote.
Great, thank you. Okay, let's start with Ryan. Ryan Brooks.
None.
I'm sorry, what?
I'm sorry, I lost connection for a second.
Oh, so did you hear the motion or not?
Yes, I did.
So how are you voting?
Yes.
Okay, thank you. Cheryl Butler?
Yes.
Thank you.
I just have one question. The issue that Mr. Martinez brought forth is there something in this that would not allow what he's speaking of?
Something.
Can we respond just kind of quickly?
Go ahead.
I think what we're talking about is that board inspectors will continue to provide education and enforcement discretion on the specific situations. If there are situations that are more complex that requires enforcement action, we really can't talk about them here. And that may be what he's referring to as some specific incident or case.
Okay. All right. I'm okay with yes.
Okay, thank you. Shirley Kim?
Yes.
Thank you. Jig?
Yes.
Thank you. Ricardo?
Yes.
Thank you. Maria?
Yes.
Thank you. Debbie?
Debbie has not yet returned.
Hasn't returned. Okay. Jason?
Yes.
Thank you. Albert?
Yes. Yes.
Thank you. I vote yes. Measure passes. Please continue, Maria.
Thank you. We're on item C, discussion and consideration of the use of peptides in compounding drug products under Section 503A of the Food, Drug, and Cosmetic Act. This next item also relates to compounding practices. Information in the chair's report detailed the relevant sections of 503A of the Food, Drug, and Cosmetic Act that describes conditions under which compounded drug may qualify for an exemption. Further, if the drug is compounded using bulk drug substance, or also called an active pharmaceutical ingredient, the bulk drug substance must comply with standards listed in the law. The details are in the meeting materials about those standards, so I won't go through them. They're pretty lengthy. So as indicated in the chair report, over the past several months, staff have identified a number of pharmacies that are compounding using peptides. Board staff have confirmed with the FDA that many peptides are not eligible for the exemptions provided under Section 503A, as they do not satisfy the criteria for bulk substance, nor do they meet the conditions described in the interim policy on compounding using bulk drug substances under Section 503A. Board staff is conducting investigations where appropriate. Further, staff is aware of pharmacies that have been issued what's called a 483 observation by the FDA. These are inspection reports of the FDA noting observed violations. This item is informational only, but we will have member comment and public comment. Members, do you have any comment?
Hi, this is I just want to say I voted yes on the previous measure.
Thank you. Did you get that? Staff are keeping track of the
Got
votes?
it.
Thank you. So for any member comment for section C? Oh, we're ready for public comment.
This is the moderator. I've opened the Q&A panel. If you'd like to request to make a public comment, please click on the Q&A icon at the bottom of your screen. Enter "I would like to make a comment" in the Ask field and submit that to all panelists.
Okay, I don't see any public comment.
No comments at this time.
Thank you. Moving on to item D, discussion and consideration of draft information for respondents describing the administrative case process. At the last Enforcement Committee meeting, we received a presentation on the administrative case process, and at the board meeting, we encouraged all board members and members of the public to view the presentation on the board's website. The presentation was an excellent overview and provided a lot of really good information. At the last board meeting, it was also suggested that it might be helpful to provide some general information to aid respondents in gaining a general understanding of the process and licensee rights. For your review in the meeting materials is a draft FAQ, frequently asked questions, as well as a flow chart to help licensees understand the process and their rights and responsibilities. I draw your attention especially to the flow chart, which is on page 100 of the Enforcement Committee report. If you want to take a moment to find that, that is a really great overview. The committee agreed with the concepts and recommends to the board that the staff finalize these informational tools, post them on our website, and distribute them to respondents in the administrative case process. We also ask staff to explore the possibility of the AG's office including this information as a part of the package of information provided to respondents. So that's our motion. Do we have any member comment? I hear shuffling of papers, but no comments. I think we're ready for public comment.
And this is the moderator, and the Q&A panel is open. To request a public comment, click the Q&A icon at the bottom of your screen. Type I would like to make a comment in the ask field and submit that to all panelists. I think everybody is,
Post-lunch.
yes.
Okay, we can close public comment.
Okay, thank you.
Mr. President, we're ready for the vote.
Great, thank you. I'll start with Albert. Albert Wong? Yes.
Yes.
Thank you. Jason?
Yes.
Thank you. Debbie? Not back yet. Okay.
Not yet.
Maria? Maria?
Yes.
Thank you. Ricardo?
Yes.
Thank you. Jig?
Yes.
Thank you. Sung?
Yes.
Thank you. Shirley? Shirley Kim? You're unmuted. I'll move on. Cheryl? Cheryl Butler?
Yes.
Thank you. Ryan?
Yes.
Thank you. I vote yes. Motion passes. Please continue, Maria.
Thank you. Item E is discussion and consideration of a proposal to develop alternative enforcement model. The committee had another very robust discussion on the potential of an alternative enforcement model to reduce time and cost associated with resolving a disciplinary matter. In our original committee discussion was based on a model used by the Physical Therapy Board that provides an option for pre-pleading settlement of a matter where the outcome is public letter of reprimand. Subsequent discussions included proposals to include board members in the settlement process or to include an oral conference as a part of the process. This was discussed further at the full board meeting where the issue was tabled. Board counsel had concerns regarding these concepts and requested time to evaluate those suggestions. Recently, during a presentation of the administrative case process that I mentioned in the previous topic, the committee, the enforcement committee, was reminded of the administrative case process has two fundamental guiding principles. First, due process of the respondent, and second, public protection. Deputy Attorney General Jarvis reminded us that the state has a duty and a responsibility to ensure the licensee is competent and trustworthy. One of the concerns brought up during public comment was that the administrative case process showed an assumption of guilt. However, there is no presumption of guilt after the filing of an accusation. The board carries the burden of proof to establish a basis for discipline. Until that burden is met, there is no presumption that the basis for discipline exists. DCA counsel Eileen Smiley reviewed her memo provided in the meeting materials that reviewed the practical challenges identified. So that memo is in the documentation, hopefully if you have a chance to read it, but I will review a few of her concerns that I find particularly worrisome. Number one, it stated, a licensee would have to agree to waive their rights to administrative adjudication and admit to the allegations to participate in an alternative enforcement process. Any disagreement with the allegations would not qualify for the alternative model. Number two, if an agreement is not reached, this could result in additional time and cost for a second hearing, in addition to legal issues that could arise on admissibility of the record. Number three, if board members participate in an alternative process, there could be open meeting act considerations requiring members to recuse themselves. Oh, excuse me. And this is the second issue. So there could be open meeting act considerations, and it could require members to recuse themselves from future discussions if an agreement is not met. Part of the issue with board members' participation, this is number four, is the alternative process would require a public meeting, since board members are present, to discuss the case, and it would be public, unlike current settlement agreements that are conducted privately with the respondent and board staff. The committee also reviewed the investigation statistics to review the facts and make decisions and not make decisions based on hearsay or individual opinions. First, when you look at the data by outcome, it's important to note that over the past 3 years, only 11% of substantiated investigations result in a referral to the Attorney General's office. Another interesting point is in looking at the number of cases and the manner in which they are resolved. Of those 11% that go to the Attorney General's office, 32% result in a default decision, 55% are resolved via settlement, and only 14% actually go to an administrative hearing. So I know that's a lot of numbers, but if you wanted to review the numbers yourself, it's on page 7 of the committee's report. And I was using fiscal year 18 and 19 in determining those percentages. But as a review, that showed that 364 cases went to the AG's office of a total of 2,100 that were reviewed. And of those 364 cases that went to the AG's office, only 2% of those made it to a hearing. So that meant that most were settled or there was a default. And looking at the data that's on that page, one of the things that jumps out at you, we had questions about, was the average processing time for case resolutions. The data shows that it is the longest time for stipulated settlements and also a significant amount of time to hearing. That kind of confused us, and so we asked for more information. Ms. Sodergren explained to the committee, and she's available on call today if during the member comment if you wanted to ask her more specifics about this or anything else. She explained to us that there are many reasons why settlement process could take longer. In some situations, respondents are interested in settling quickly and the matter is resolved. In other situations, respondents only become actively involved in the settlement process as their hearing date approaches. So the committee discussed the options for an alternative enforcement model. We also discussed the potential of moving forward with what a physical therapy board model would look like. Both of these would require statutory changes. After another lively discussion, very lively, the committee members have no motion for the board at this time. We decided that we will continue to evaluate and study the issue at our next regularly scheduled meeting. As I mentioned, both Ms. Sodergren and Ms. Smiley, our DCA counsel, are present on this call should members have any specific questions for them during the member comment. So we're ready for member comments. Quiet group. Then we're ready for public comment.
This is the moderator. I've opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen. Type "I would like to make a comment" in the Ask field and submit that to all panelists. Our first comment comes from Daniel Martinez. Daniel, your line is open and you will have 2 minutes.
Thank you. Danny Martinez with CPHA. As I mentioned yesterday, there is a need for this. We did have we were kind of the nexus of this idea back in July of 2019, as per the letter that we've submitted to the committee and to the board. Given yesterday's discussions on this issue, I'm not going to re-emphasize what was said there. All I'm going to say is that I appreciate the opportunity to discuss this matter further and to clarify exactly what the intent of this is, as I believe yesterday there was some confusion as to why this proposal came out in the first place. I did want to clarify, as I did yesterday, that this proposal that you're seeing is not our original proposal. It is not anywhere near what our proposal had mentioned. But we do look forward to actually providing a necessity, a reason for this that hopefully will be clarified at the next enforcement meeting. Thank you.
Thank you, Danny.
At this time, we have no additional requests for public comment. Would you like me to close the Q&A panel?
Please do. Thank you. Our next item on the agenda is item F, discussion and consideration of proposal of board policy encouraging pharmacies to report to law enforcement acts involving drug diversion by an employee. During our January 2020 board meeting, the board approved policy intended to encourage pharmacies to refer drug diversion cases to local law enforcement agencies for possible prosecution. Such referral would be in addition to mandatory reporting to the board. Page 8 of the committee's report has the official policy statement that was previously approved. Data also provided in the materials indicate that referrals to law enforcement are occurring. However, they may not be occurring in the frequency that the board would expect. Therefore, the committee recommends to the board to include our policy statement in communication to licensees when seeking information regarding drug losses. Are there any member comment? Hearing none, we'll go to public comment.
This is the moderator. I've opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen. Enter "I would like to make a comment" in the Ask field and submit that to all panelists.
I don't see any public comment.
Not at this time.
Okay, we'll close public comment. And Mr. President, we're ready for the vote.
Very good. Let's begin with you, Maria.
Yes.
Thank you. Cheryl?
Yes.
Thank you. Shirley?
Yes.
Thank you. Ryan?
Yes.
Thank you. Albert?
Yes.
Thank you. Sung?
Yes.
Thank you. And is Jason back?
I'm here and a yes.
Thank you. Jig?
Yes.
Thank you. Ricardo?
Yes.
Thank you. I vote yes. Shelley, did Debbie come back or not?
Not yet.
Okay, thank you. Motion passes. Back to you, Maria.
Thank you. Next item on the agenda is G, discussion and consideration of disciplinary cases and the incorporation of ethics program requirement. As included in the meeting materials, the requirement for the ethics programs are established by regulation. Recently, the board received a request to discuss what appeared to be a decrease in the number of disciplinary orders that include, as a condition of probation, completion of an ethics course. Information about the ethics program are detailed in the committee's report on page 9, so I'll only highlight a few items. The program must include a minimum of 22 hours, at least 14 of which are contact hours and 8 additional hours for preparation, evaluation, and assessment. The course objectives are listed in the report. The cost for the program by PBI Education is $1,875. Data on the number of individuals that have completed the PBI training is provided also. Regrettably, staff was unable to secure data from IMQ. IMQ, until recently, was another course provider, but has since closed. The data confirms that there is a decline in requiring ethics program as a condition of probation. Staff indicated that a part of this decline may be that respondents are proactively participating in the ethics program as a part of preparing for their response during the disciplinary process. Dr. Yoshizuka from Touro University also stated during public comment that perhaps the universities could be more involved in developing and administering an ethics course that meets the board's criteria. This item is informational only, So we will have member comment and public comment only. Members, do you have any comment? Hearing none, I think we could go to public comment.
This is the moderator. I've opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen. Type, I would like to make a comment into the ask field and submit that to all panelists.
Okay, thank you. I think we're ready
You're
to
welcome.
close. Next item on the agenda is review and discussion of enforcement statistics. The meeting materials include the quarterly enforcement statistics. They are there for your review and for your information. Is there any member comment or questions regarding the statistics?
We've had serious decline in disciplinary matters, huh? Ethics. Oh, that's the ethics now. Okay.
Yeah, it's the next attachment is the quarterly enforcement statistics.
Oh, okay. Okay.
Any questions or comments regarding the quarterly enforcement statistics? Hearing none, let's go to public comment.
This is the moderator. I've opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen. Enter, I would like to make a comment into the ask field and submit that to all panelists.
Okay, thank you.
You're welcome.
The last item on the agenda is the meeting dates for 2021 that are listed. Mr. President, that concludes the report of the Enforcement and Compounding Committee.
Thank you, Maria. Okay, next item is item 13, which is the Legislation Regulation Committee report. As the chairperson of that committee, I will now provide a summary of the committee's discussion during our meeting yesterday. First, I will be providing an update on legislation previously considered by the board. This is for information only and intended to provide members with outcomes of the various measures considered by the board. As the information I will be reviewing is for information only, I will not seek member comments or public comment until the end of the updates. Now, a few of these bills were already discussed in the enforcement report, but I'm going to go by them pretty quickly anyway. First is Assembly Bill 1710. This measure provides pharmacists with authority independently independently order and administer FDA authorized or approved COVID-19 vaccines. The board had a support position on the measure and it's been chaptered. Assembly Bill 2028 would have amended provisions of the Open Meetings Act. As indicated in the meeting materials, the board had established an opposed and less amended position on the measure. Subsequent amendments were made that would have addressed the board's concerns. However, the bill failed passage. Next would be Assembly Bill 2077. This bill extends until January 1, 2026, the sunset date of current law that allows the retail sale or furnishing of a hypodermic needle or syringe to a person 18 years of age or older without a prescription. The board had a support position on the measure, and the measure has been chaptered. Next is Assembly Bill 2113, which will require boards within the DCA to expedite the initial licensure process for an applicant who supplies satisfactory evidence to the board that the applicant is a refugee, been granted political asylum, or possesses a special immigrant visa. As indicated in the materials, the board did not have a position on the measure, and the measure has been chaptered. Next is Assembly Bill 2549, which the measure would have required the board to issue temporary licenses to military spouses and require the board to promulgate regulations. Under the provisions of the measure, the temporary license would have been good for up to 12 months. During our prior discussion of the measure, the board expressed concerns with the measure as the board would have lost the ability to assess for minimum competency. prior to issuing a temporary pharmacist license. The board had an opposed unless amended position on the measure, and the measure failed. Next is Assembly Bill 2983. This measure would have prohibited pharmacy from automatically contacting a prescriber to request refill authorization unless the prescriber or patient had expressly authorized such contact. The board did not have a position on the measure, and the measure failed. Next is Assembly Bill 3045. This bill would have required boards with the DCA to issue a license to an applicant if the applicant met specified requirements, including that the applicant was honorably discharged from the armed forces, or married, or in a domestic partnership or other legal union with an active duty member. This measure also failed passage. As you may recall, the board established an opposed unless amended position because of concerns about the board's inability to assess for minimum competency. Next is Assembly Bill 3342. The board established a support position on AB 3342. As related to the board's jurisdiction, this measure would have authorized the pharmacy to furnish epinephrine auto-injectors to the State Department of Healthcare Services under the program created pursuant to the bill, subject to similar requirements. The measure failed passage. Next is Senate Bill 878, which was signed by the governor and will require boards within the DCA to prominently display the current time frame for processing initial and renewal license applications on its internet website. As the committee and board previously discussed, the board publicly reports application processing times as part of the quarterly licensing committee and board meetings. The board did not have an established position on the measure. Next and final is SB 1474, which extends the operations of several boards for 1 year, including our board, to allow for review by oversight committees in the coming year. As we previously discussed, due to the COVID-19 pandemic and the unprecedented nature of the 2020 legislative session, oversight review was postponed. And the bill, let's see, and the bill was chaptered. Okay, so now just having reviewed the measures, now's the time for comments if you have one. So anybody having a comment, please speak up. Not hearing any. Shelley, let's open up for public comment.
This is the moderator. I've opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen. Type "I would like to make a comment" into the ask field and submit that to all panelists. Seeing none,
Okay.
would you like me to close the panel?
Yes, please.
I have done so. And just so you know, President Debbie Veal has returned. Her audio is not yet connected through, but she is back.
Okay, thank you. That was the end of the legislation portion of the report. So now comes the regulation report. The regulations portion of my report is also informational only. As such, I will ask for comments following each agenda section as opposed to following each regulation. Comments can extend to any of the regulations covered. Some of these sections only have one regulation. So I think what I'm going to do is those that only have one, I'm going to wait until we cover 2 or 3 before I ask for comments. So,
hey, Greg, this is Debbie Veal. I want to let you know I've rejoined.
Thank you. Okay. First regulation is under the section of board adopted regulations approved by the Office of Administrative Law. And there is only this one regulation in this section. The community pharmacy staffing regulation, which establishes the criteria a pharmacy must meet to identify and ensure a person is assigned to assist a pharmacist in compliance with BPC Section 4113.5. The regulation took effect on September 15th, 2020. Next is the section discussion and consideration of board adopted regulations undergoing final review by the Office of Administrative Law. And since this one has more than one, I will go back and ask if there are any comments on the one I just read. If there are no member comments, I know Cheryl had a comment yesterday. I don't know if you want to state it again today.
Yes, I just wanted to just say how much I know that the pharmacists that are working along really appreciate this. Actually, now as of September 15th, that they actually have what that they need. And thank you.
Thank you, Cheryl. Having no other member comments, let's open up for public comment.
This is the moderator. I've opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen. Type "I would like to make a comment" into the Ask field and submit that to all panelists.
Okay, it doesn't appear we're going to have any, so let's close it up.
It is closed.
Thank you. Okay, next is discussion consideration of board adopted regulations undergoing final review by the Office of Administrative Law. The board has two regulations undergoing final review by the Office of Administrative Law. The first is proposed regulation to amend Title 16, Sections 1769 and 1770, substantial relationship and rehabilitation criteria. When finalized, this proposal will increase transparency and provide clarity to license applicants with respect to the rehabilitation criteria the board considers when evaluating an applicant's eligibility for licensure. The OAL decision is expected by October, well, it was expected by October 27th. And do we have any update on this?
Yes, the extension was granted, so they have an additional 60 days.
Okay, thank you. Next is the proposed regulation to amend Title 16, Sections 1702, 1702.1, 1702.5, renewal requirements. This proposal updates the renewal requirement language to apply similarly across most licensing programs. Such an approach will reduce administrative workload associated when new licensing programs are established. As indicated in the meeting materials, the OAL decision is due November 2nd. However, it may be extended under the provisions of the governor's executive order. Members, are there any comments on these last two that I read in this section? Okay, hearing none, let's open up for public comment.
This is the moderator. We have opened the Q&A panel and are displaying instructions on the screen. If you'd like to make a comment, please click on the Q&A icon at the bottom of your screen. Type "I would like to make a comment" into the Ask field and submit that to all panelists.
Okay, looks like it's not going to happen, so let's close it up.
It is closed.
Okay, the next two sections each have one regulation apiece, so I'm just going to read them together. Section discussion and consideration of board adopted regulations undergoing formal review by the Department of Consumer Affairs or the Business Consumer Services and Housing Agency. The board has one regulation undergoing formal review. Proposed regulation to amend Title 16, Section 1707, off-site storage. The proposal amends the board's regulation regarding the waiver requirements for off-site storage of records. Under the proposed revisions, entities previously cited for a records violation will be eligible for such a waiver. The measure was adopted by the executive officer on June 3rd, 2020, consistent with our delegation after no negative comments were received. The proposal is currently undergoing formal review by agency. Next one is Discussion and consideration of board adopted regulations, staff drafting final rulemaking documents for final review by the Department of Consumer Affairs and the Business Consumer Services and Housing Agency. As mentioned, the board currently has one regulation under this category. It's proposed regulation to amend Title 16 CCR sections 1708 to 1783 related to dangerous drug distributors and third-party logistics providers. The proposal establishes the regulatory framework for third-party logistics providers. The measure was adopted by the board on July 27th. Members, do you have any comments on either of these last two that I just read? Okay, let's open for public comment.
This is the moderator. I've opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen. Type "I would like to make a comment" into the Ask field and submit that to all panelists. It is going to be a quiet bunch this afternoon, President
Yes.
Libby.
Once again. Okay.
I will close the panel.
Thank you.
You have a full stomach, that's why.
Yeah, well, plus it's all informational. Anyway, next is discussion consideration of board approved regulations undergoing pre-notice review by the Department of Consumer Affairs or the Business Consumer Services and Housing Agency. At the time of releasing the materials, the board had 5 regulation packages undergoing pre-notice review. The first is proposed regulations to amend Title 16 CCR Section 1715 to update self-assessment forms 17M-13 and 17M-14. This proposal updates the self-assessment forms 17M-13 and 17M-14 as incorporated by reference in Title 16 CCR Section 1715. Additionally, this regulation updates Section 1715 with the clarifying language as to the completion and certification requirements of the self-assessment forms. I note it has been undergoing pre-notice review since December of 2018. Next is proposed regulations to amend Title 16 CCR Section 1784 to update the wholesale 3PL self-assessment form 17M-26. The proposal updates the self-assessment form 17M-26 as incorporated by reference in Title 16 CCR Section 1784. Additionally, this regulation updates Section 1784 with clarifying language as to the completion and certification requirements of the self-assessment form. As with the prior package, this regulation proposal has also been undergoing pre-notice review since December 2018. Next is proposed permanent regulation to add Title 16 CCR Section 1747 related to independent HIV pre-exposure and post-exposure prophylaxis furnishing. The proposal will make permanent the emergency regulations that establish the criteria for training programs to meet in order to be offered to pharmacists so that the pharmacist may independently initiate and furnish PEP and PrEP prophylaxis. Pre-notice review on this package started on February 7th, 2020. Next is proposed regulation to amend Title 16 CCR Section 1715.65 related to inventory reconciliation. This proposal amends and clarifies the requirements for the completion of the inventory reconciliation report. The package was referred to DCA for pre-notice review on May 11th, 2020. The final one in this section is proposed regulation to amend Title 16 CCR Section 1715.6 related to drug losses. This proposal amends the drug loss reporting requirements to further define when drug losses must be reported to increase clarity for the regulated public. The package was referred to DCA for pre-notice review on June 3rd, 2020. Members, are there any comments on any of the 5 regulations, proposed regulations in this section? Okay, hearing none, let's open for public comment.
This is the moderator. We've opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen. Type "I would like to make a comment" into the Ask field and submit that to all panelists.
Okay, let's close it.
It is closed.
Thank you. Next section is discussion and consideration of board-approved text to initiate rulemaking, staff drafting documents for pre-notice review by the Department of Consumer Affairs and the Business Consumer Services and Housing Agency. This section has 4 regulations that are currently with board staff to either draft rulemaking documents for pre-notice review or to evaluate information provided by DCA in response to board submission of documents for the pre-notice review. The first is proposed regulations to amend Title 16 CCR Section 1793.5 related to the pharmacy technician application, Section 1793.6 related to the pharmacy technician training requirements, and Section 1793.65 related to the pharmacy technician certification programs. This proposal establishes the training requirements and certification programs and updates the application for licensure for pharmacy technicians. This regulation package was originally approved by the board in October of 2016. Changes have been requested on a few occasions. The package was resubmitted for pre-notice review in October of 2018, returned to the board for amendments to implement provisions of AB 2138 in 2019. Most recently, on September 3rd, 2020, the rulemaking package was again returned to the board staff. Staff will be reviewing the recommendations offered by DCA to determine the appropriate course of action. Next is proposed regulation to amend Title 16 CCR Section 1709 related to pharmacy ownership, management, and control, including through trusts. This proposal amends the board's regulations regarding ownership to include provisions relating to trust ownership of pharmacies. The package was returned to the board on April 22nd, 2020. This package was originally approved by the board in October of 2016. As with the prior regulation, changes have been requested on several occasions. I've been advised that subsequent to the release of the meeting materials, board staff provided the requested information to DCA. Next is proposed regulation to amend Title 16 CCR Section 1704 related to address change notification. During our July 2020 meeting, the board approved initiation of a rulemaking to require a licensee to maintain a current email address with the board, should the licensee have one. The final proposed regulation in this section is proposed regulation to add Title 16 CCR Section 1708.1 related to the temporary closure of facilities. During our July 2020 meeting, the board also approved initiation of a rulemaking that will establish notification requirements of the temporary closure of licensed facilities. Members, do you have any comments on the 4 proposed regulations I just read? Hearing none, let's go to public comment.
This is the moderator. I've opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon at the bottom of the screen. Type "I would like to make a comment" into the Ask field and submit that to all panelists. Seeing none.
Okay, time to close. Thank you. Okay, next item is future committee meeting dates. Our committee's next meeting is scheduled for January 27th, 2021, and that is the end of my report. Next is the executive officer's report. And Sodergren, please give your report.
Thank you very much for the opportunity to present today. I wanted to provide just a few quick updates. The first of which is talking about the board's response to COVID-19. So I'm not going to review all of the information. It is detailed in the meeting materials, but we are continuing to evaluate the broad waivers and have made we have extended those that were appropriate based on President Libby's direction. I would like to note that during our next meeting in December, we will most likely need to spend quite a bit of time discussing the broad waivers, as we have now reached the maximum delegated authority for President Libby. But the current broad waivers are detailed in the plan, in the report, and when a broad waiver expires, as part of our notification of expiration, licensees are reminded of the option to secure or request a site-specific waiver, and we are continuing to work on those. In addition, I wanted to quickly highlight that since our last meeting, the DCA director did approve a waiver to expand testing authority for CLIA waived point-of-care testing for COVID, and that information is in the web, is provided in the packet as well. We are issuing temporary licenses and have been working in a number of areas to issue temporary licenses. Most recently, it's been working to issue temporary licenses to wholesalers and non-resident wholesalers, out-of-state distributors, as part of Operation Warp Speed, to ensure that there's sufficient and appropriate infrastructure in place to distribute vaccinations once they're approved and ready to go. We are continuing to make changes operationally. We continue to reassess. We have a number of staff that continue to telework. Our field staff have resumed inspections for several months now. We continue to use protections when they are in the field and partner with the work sites to ensure that it's safe for everybody involved. Are there any questions, Greg, on COVID?
It's up to the members.
Okay, hearing none, I'll just keep going if that's okay.
Yep.
The next thing I wanted to quickly discuss is the sunset review process. So as you may recall, last December, we did submit our sunset review report. We were scheduled for a hearing, but due to the COVID pandemic, our hearing was postponed indefinitely. We have recently been advised that we will be up for review next year. We have been given the opportunity to provide an update on both our sunset report as well as to answer specific COVID-related questions. So I've included the questions that we will be responding to. With that, I do note that historically the board has reviewed and approved the sunset report prior to its release. And so one of the items that I would like to ask for the board's preference on is if they would like me to draft the report and work with a board member that's been delegated and then bring it to the full board at a subsequent meeting, or is it the board's preference to schedule a board meeting in advance of December 1 to ensure that all members have the opportunity to review it before we move forward? I would anticipate that in addition to providing updates with respect to data for the last fiscal year and all of our COVID efforts, I do think that there may be some policy issues that have arisen out of the COVID pandemic that may also be appropriate. So if we are able to schedule a meeting in advance, it may give members the opportunity to discuss some of the policy and whether or not it's appropriate to include it in the sunset report. With that, Greg, I'll turn it back over to you for a minute.
Okay, thank you. Last time when we were getting ready to deal with the sunset report, we had delegated it to Debbie Veal and to Ann to work on. I don't know if that's what we want to do again, or if we want to have the full board involvement. So what I'd like to do is get some ideas of how the board members feel about that. So I'm going to go ahead with a roll call. First of all, Debbie, how would you feel about doing that again? Let me know.
It would be my pleasure.
Thank you. One of the reasons Debbie was selected to do this is because she did this in our last sunset report 5 years ago. Did a great job. So anyway, I'm going to.
Excuse me.
Yes.
My concern is this particular. I understand 5 years ago, but this particular sunset review, you say, will include updates as far as COVID is concerned, correct?
Correct. Yeah,
Okay.
it'll include the updates of all the things that we've done related to COVID, which basically is, numerous waivers that have been issued.
But I think just to clarify too for everyone to know is that Debbie worked with Ann just within the last year on the most recent sunset report. So it's not just 5 years ago. It's
yeah, exactly. That's what I meant. When we dealt with this last time, which was this last year, and what happened was because of COVID, we did not wind up testifying. So it was extended for another year. So Debbie's already spent a lot of time developing the information for the sunset report. So the question is, do we want her to continue? I should have been more clear about that. Thank you, Maria.
Okay. Okay. That was my question.
Okay. Thank you. Sung, what is your thought on this?
That sounds great to me.
Okay. Ryan?
I'm good also.
Thank you. Maria?
Yes, I agree. Debbie and Ann did a wonderful job last time. Maybe they could, like they did before, send us the last draft. So
yes, absolutely.
that
will be done.
Before it gets presented, yeah. Thanks.
Yes, thank you. Okay, Jig?
I'm good with it. Thank you.
Thank you. Cheryl, you already said you're good with it. Albert? Albert?
No objection. Be happy to let her do it.
Thank you. Jason?
I am fine with the delegation to Debbie. At the end of this, I think I would have to abstain from any vote anyhow due to my employment with the legislature. Thank you.
Correct. Thank you. Okay, Ricardo?
I'm fine with it also.
Thank you, as am I. Okay, and that's,
Mr. President.
That's the end.
Mr. President,
Yeah.
I apologize for that, for interrupting. I just wanted to check in really fast with Board Member Serpa. Happy to submit the draft, but comments would not be, you would be seeing the draft, but you would not be seeing, there would not be an opportunity to provide comments back until after if we delegate. And I just wanted to make sure that was understood.
I think I understand because I know last time we had suggestions for additions or we saw some gaps. So I think within the last year is probably not going to have so many suggestions. So are you saying you would distribute it after it was final?
No, she's saying that she would distribute the draft, but you wouldn't see the subsequent comments from the testifying until after.
No. But my original question was distributing the final draft so that we could provide comments before providing the information to the legislature. Is that not possible? The timing is not right?
I think that would have to be done through a board meeting, but I'll defer to council on that.
All right. Council, can we hear from you?
And can you repeat what you need the clarification on exactly?
So the draft sunset report, the supplemental report, the question is, if Debbie Veal is delegated authority to work with staff to finalize the report, would other board members be able to also provide comments on the draft outside of a board meeting?
I think you might have some open meeting act
Right.
if you do that, because then Debbie is kind of acting as the hub of the wheel, and with the other board members being the sort of spokes. So depending on what is left over, whether or not it's something like, hey, you missed typos or something along those lines. We're not talking about discussion of policy issues, but where you're talking about the delegation involving the either clarification of or inclusion of any kind of policy issues, I think you would want to have any substantive amendments to the report reviewed by the full board at a board meeting.
Okay,
So with that complication, I don't think it's an issue this year, since we have reviewed it just within the last year. And potentially the only inclusions are going to be things that are just from the last year, including COVID. So
right.
I don't think it needs a special board meeting for that. But for the next one, I mean, I think that should not be our routine, but because it's only a 1-year extension, it's probably a moot point.
Thank you.
Okay, I'm trying to, it seems like as board members, we should be able to provide comments, but, so you're saying we will not be able to comment at all?
I guess it would have to be in a board meeting. So we would have to have
Cheryl, I think that's the decision point is, what all do you want to do? If you want to provide comments before the submission, the due date is December 1st. So we'll work to schedule a board meeting in the end of November. If you all feel comfortable not doing that, it's just whatever your preference is, we will implement as you all guide us to do. I was just laying out different options for the board, and then you tell me how you want it to be done.
Okay, well, it seems that the majority of the board members would not want to be able to make comments. I think I'd like to be able to provide a comment, but the majority rules. But I
think
have
if you had something that you wanted to make sure is in there, I think you could communicate that to Ann.
Yeah, I would like to be able to have that option.
I mean, that would not be a violation of any meeting if you specifically had something you wanted in there and you wanted to communicate it to Ann, as far as I know. Am I correct in that, Council?
I'd like to be able to, make a comment if I feel it's necessary. But so that's, like I said, that's my opinion.
Greg?
Yes.
This is just related to the 5 questions on executive officer report, right, Ann and Greg?
So it's also updates on, they've asked for updates since our last report, right? So we'll be providing some updates on different things, right? We'll highlight, we have a new board member, probably provide an update on the CPJE. We're providing the new data for the next year. So we'll be providing updates on things, but as well, but it'll also focus on the COVID questions specifically. We need to provide that. Hearing that some members may be interested, I guess I should have thrown out 3 different options, so I'm apologizing that I didn't do that up front. The board could delegate it to a committee and we could review it. It would be in an open meeting, but we could delegate to a committee, and then any members that wanted to participate could. And then those that didn't want to, they can review the final at another point. That's another option. Sorry, I didn't think of that earlier.
So you're saying it would be a committee meeting? And?
Yes, I think that's another option.
A committee meeting. A separate committee.
Greg, I almost think it seems like there's enough people that are interested, and it seems like if we had are we going to maybe need, I'm starting to think that we should have a board meeting, and maybe it's just a short board meeting, but it seems like maybe at some point in late-ish November, we should have a board meeting and go over the sunset.
That may be a good idea too. I mean, I'm okay either way, but
Okay.
I think yeah.
Let's go ahead and try and schedule one then. Ann?
Yeah, that sounds great. We'll look at some dates. I will avoid November 26th and November 27th. You're welcome. That's Thanksgiving, just so you know. The
Thank you.
last thing, I am just a giver that way.
I
the last thing
thought
that I just
maybe we would all meet in Sacramento and you'd feed us Thanksgiving dinner.
Oh, that may even be
trust
better.
me.
Socially,
trust me, you don't want me cooking. You don't want me cooking.
Socially distanced. Yeah.
So just the last thing in my report is just the pass rates for the biennial report. I want to let you know that it's posted on our website. It's included in the meeting materials, and we have also provided it to the California schools. And that's my report. Thank you for your time.
Thank you, Ann.
And
do we have any public comment on the executive officer's report? Let's open it up.
Can I ask a question?
Sure.
And a question. And I see that as reported in July in partnership with other state agencies, that the inspector staff has began checking compliance with statewide face mask requirements and physical distancing and protective measures. So you say that as of today, they've actually done on-site inspections, like 725 of them?
Yes, we've been doing a number of inspections, and in partnering with the administration, we are now also reviewing for those things. When we identify that there's maybe an opportunity for some improvement at a facility, we're discussing perhaps, where they need to improve their practices, and we're also providing the guidance documents that are available specific to pharmacies.
Thank you. I'm happy to hear that. Thank you.
Okay, we're open for public comment.
We are open. I have opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen. Enter "I would like to make a comment" into the Ask field and submit it to all panelists. We have a request for comment from Danny Martinez. Danny, your line is open and you will have 2 minutes.
Hi, thanks. Danny Martinez from CPHA. I just had a quick question on the executive officer's report. And I know that this was discussed at the last full board meeting, but is the executive officer or anyone able to share any, even just not even specific, but just overarching comments on the inspectors who are trying to comply or going out there trying to get mask compliance? I've had a couple of our members be a little bit concerned with that. I just want to know if you're able to share any statistics based on what the executive officer's report reflects.
That would be for Ann.
So I'm not quite sure I fully understand what is being asked. I would say that the majority of the time, I would say 99% of the time, if an issue is identified where maybe staff are not wearing their masks appropriately, or there's no physical barriers, or hand washing is not happening, we're doing education. We're providing them with copies of the guidance documents that are relevant, and then discussing it as a way to educate and improve the practice.
Perfect. Thank you very much.
Thank you.
And we have no additional requests for comment. Would you like me to close the panel?
Yes, please. Okay, the next agenda item is an update from the Department of Consumer Affairs. Do we have Ms. Carrie Holmes with us?
Yes, good afternoon.
Good afternoon.
All right, well, good afternoon, board members as well. It's a pleasure to be with you today. I'm Carrie Holmes, Deputy Director for Board and Bureau Relations at the Department of Consumer Affairs. Thank you for inviting me again to your meeting to provide a department update to the Pharmacy Board. I'd like to welcome Jason Weiss as the newest member of the board. Congratulations on your appointment, and thank you for your willingness to serve. One of my top priorities in Board and Bureau Relations is appointments, and I'd like to provide you with a brief overview. The Board of Pharmacy is comprised of 13 members, 11 of whom are appointed by the governor and one each by Senate rules and the Speaker of the Assembly. 7 of the governor's appointments must be licensed pharmacists, and 5 are required to represent specific practice settings: an acute care hospital, an independent community pharmacy, a chain community pharmacy, and a long-term health care or skilled nursing facility. Currently, the board has 2 vacancies: a public member appointed by the Speaker of the Assembly and a licensee member representing long-term care or skilled nursing appointed by the governor. Additionally, and sadly, 3 members have reached their term limits and will not be able to be reappointed upcoming. DCA and all the appointing authorities share the goal of a fully seated, diverse, and effective board. Filling current and upcoming vacancies is a priority. That being said, if any members know any great candidates, or if any members of the public attending the meeting are interested in getting involved, please find the link Board Member Resources on DCA's homepage and apply for an appointment. Now I would like to give a brief update from DCA's Office of Human Resources. Later this week, some members may receive a letter from the Office of Human Resources regarding the Part-Time, Seasonal, and Temporary Employees Retirement Program, or PST. Several members have been involved in PST since the time of their appointment as a member with DCA. CalHR has changed its criteria and provided new guidance that members are no longer eligible for PST. In consultation with CalHR and SEO, all members will be removed from PST and contributions from the date of appointment will be refunded to the members. Members will receive corrected wage and tax statements for the applicable tax years. In most cases, this will be a very small dollar amount. Once you receive your letter, if you have any questions, please contact Daniela Ruffin with the Department's Office of Human Resources. Her contact information will be on the letter you receive. Shortly before the board's July meeting, DCA and its boards and bureaus had just reopened offices to the public after a temporary closure due to state and local stay-at-home orders to prevent the spread of COVID-19. DCA offices remain open with preventative measures to safeguard the health and safety of our employees and visitors. DCA continues to partner with the Governor's Office and Business Consumer Services and Housing Agency on statewide efforts related to awareness and enforcement of public health measures. DCA would like to thank the Board of Pharmacy for its role in public health education and enforcement. The department is truly grateful to all members for your continued service and to the staff who are being so flexible and productive. Thank you very much to Executive Officer Sodegren, too, for her daily reporting and always being willing to assist the Executive Office with issues related to COVID testing, vaccinations, and other issues where she provides guidance. Thank you again for inviting me to your meeting. I look forward to the day when we can meet in person. If you have any questions or need anything from DCA, please don't hesitate to reach out. That concludes my presentation.
Thank you, Carrie. Okay. It looks like we have come to the end of our meeting. So thank you all for participating, and we will see you at our next meeting. Or at least
Greg, are we gonna just stay? Are we gonna just stay on here for the next 3 o'clock one?
Yeah, there's an emergency
We have an emergency meeting coming up right after this. So those who
Are we staying on here?
those who are going to attend the emergency meeting, just stay on.
Emergency meeting is that? Does it involve us?
Yes, it does. So let's begin that meeting in 10 minutes, okay? We'll take a 10-minute break.
All right.
I don't know the answer to that. Anne, is that going to be?
If you're available, yeah, I think if you're available, that would be great. Thank you.
Okay.
I believe that the agenda indicates that there's going to be a webcast.
Okay. Well,
Actually, I'm not sure about that. Actually, I'm trying to figure out which part is the emergency part. But Cesar, if you're available, that'd be great.
Okay.
And this is the moderator. Would you prefer that I just continue on the same recording or start a new recording for the emergency meeting?
Can we continue on the same one, or?
We
Ann?
can. I can just leave it running. Yes.
Okay, why don't we just do that?
Okay.
I have to
Okay,
make sure that it's the same connection that's listed in the agenda. That's all.
yes, yes, it is. Okay, let's take a 10-minute break. Albert,
Here.
thank you. Jason?
This meeting is being recorded.
Oh, there we go.
Here.
Thank you. Debbie?
Here.
Thank you. Maria?
Here.
Thank you. Ricardo?
Here.
Thank you. Jig?
Here.
Thank you. Sung?
Here.
Thank you. Shirley? Shirley? Okay, I'll go on to Cheryl.
Here.
Thank you. Ryan, you're here. I know. I'm here. Okay. All right. And our moderator's back, I believe.
Yes, I am. And Shirley has not yet rejoined, but I am watching for her.
Okay, thank you. Okay. Good afternoon. After adjourning our previous board meeting, I am now going to convene the emergency meeting as agendized. For those who may be just joining, my name is Greg Lippy and I'm board president. Before we convene, as mentioned during our prior board meeting, all lines are currently on mute. I will announce when we are accepting public comment on the various issues, and the moderator will open the lines as appropriate. I've advised staff to allot 2 minutes to each individual providing comments. I already took the roll call, so I don't need to do that. And we'll now proceed to agenda item 2 on the emergency meeting agenda. I first want to say that the purpose for the meeting is that I had issued a waiver, which was a 30-day waiver, which was my authority to do, related to an issue that resulted from the fires up in the Napa area. My authority for the 90 days and 90 days extensions and so on relates to COVID, but not to the fires. So what we need to do here is, first of all, we need to determine if an emergency exists pursuant to Government Code Section 11125.3. And subsequent to the posting of the board's agenda for the prior meeting, it came to the attention of the board that the extension that was granted previously needed to be considered by the board. So that's the reason why it's an emergency meeting, because we didn't come to our attention until after the previous meeting had been noticed. So the board may take action on an item of business via an emergency meeting, which this is, upon a determination by a majority vote of the board that an emergency situation exists. And that is defined as a work stoppage or other activity that severely impairs public health or safety or both, or a crippling disaster that severely impairs public health or safety or both. That determination must be made by a 2/3 vote of the state body. We are being asked as a body to determine if the declared disaster resulting from the wildfires in Napa, Sonoma, and Shasta counties satisfies either of the conditions that I just reviewed. I believe the impact of the wildfires does satisfy those conditions. Members, I'll now ask for your comments regarding making a determination that an emergency exists and to allow the board to consider a request to waive a provision of pharmacy law consistent with the authority established in PPC section 4062, and for comments on a motion, if any. Members that wish to speak, please open the line.
So, Mr. President, I'm assuming the motion is to extend the waiver.
It's to, yes, it's to extend the waiver.
Yeah, so I will make a motion to extend the waiver.
I believe the first motion.
Well, I think we first have to determine that it's an emergency.
Correct.
Okay.
So I'll amend my motion to first concur and establish that a current emergency exists.
Okay, your motion is to determine that we have determined that an emergency situation exists, correct?
An emergency exists that would create hardship if the board waited the required 10 days to hold a meeting, right?
Yes, that's what Ryan said.
Great. Thanks.
I'll second that, President.
Okay, thank you, Ricardo. Okay, do we have any other member comments related to this? Okay, let's open up for public comment.
This is the moderator. I have opened the Q&A panel for public comment. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen. Enter, I would like to make a comment into the Ask section, and then submit that to all panelists.
Well, looks like we don't have any comments.
Seeing none, I will close the panel.
Okay, in that case, we'll take a vote on whether the emergency exists. Why don't you state that wording again, Lorraine? Hello?
I'm sorry. I'm on mute. I was on mute.
Okay, go ahead. State the wording again. Just
The wording of the motion that
yes,
for
that
item number
was made.
2, yeah, that what
Right.
to determine that an emergency exists to allow the board to consider the matter due to I'm sorry, I don't have my open meetings in front of me, but due to the possibility that harm would occur if the board waited the 10 days to notice an additional meeting.
Correct. Okay, great. Okay, that's what we're voting on. So let's start with Ryan.
Yes.
Thank you. Cheryl?
Yes.
Thank you. Shirley, are you back? Nope. Okay. Sung?
Yes.
Thank you. Jig?
Yes.
Thank you. Maria?
Yes.
Thank you. Ricardo?
Yes.
Thank you. Debbie?
Yes.
Thank you. Jason?
Yes.
Thank you. Albert?
Yes.
Thank you. I'm a yes. That motion passes. Okay. Okay, now that the determination of emergency has been made, we will now proceed to agenda item 3 to discuss a request to extend the site-specific waiver issued to Adventist Health's St. Helena Hospital. Consistent with the board's policy, as president, I granted a waiver from Business Profession Code Section 4059.5A and B for a period of 30 days, as I previously mentioned. As a result of the wildfires, St. Helena Hospital was evacuated to allow for continuity of patient care. Alternative care sites were necessary. As president, I approved a waiver of BPC 4059.5A and B to allow Cardinal Health to the drug wholesaler to deliver medication to the alternate care location to allow oncology patients to continue receiving their treatments. Board staff was recently advised that the hospital will remain closed until as late as December. We need a motion to extend the waiver, and I believe that we want to extend it for at least 90 days. So, is that going to, what's that?
I just said that I would like to make that motion.
Okay, thank you, Cheryl. We have a second?
I can second that. This is
Sean, sorry. Yes. Second?
I'll second that.
yes, I can second that.
Yeah, I'm sorry, it's hard for me to hear on it.
Yes, I believe that Sung seconded the motion, and the motion is to extend the waiver for 90 days.
Okay, and Cheryl was the one who made the motion?
Yes.
Yes.
Okay, thank you. Yeah, things are breaking up here and it's a little bit tough for me to hear, sorry. Okay, all right, do we have any member comments? No comments. Okay, let's open up for public comment.
This is the moderator. I have opened the Q&A panel. If you'd like to make a comment, please click on the Q&A icon at the bottom of your screen. Type, I would like to make a comment into the ask field and submit that to all panelists. No requests have been received thus far.
Okay, let's close it up.
It is closed.
Okay, so we will be voting on a 90-day extension. We have a motion, we have a second. So I will begin with Sung.
Yes.
Thank you. Ricardo?
Yes.
Thank you. Maria?
Yes.
Thank you. Albert?
Yes.
Thank you. Jason?
Yes.
Thank you. Jig?
Yes.
Thank you. Debbie?
Yes.
Thank you. Is Shirley back?
She is not.
Okay. Ryan?
Yes.
Thank you. Cheryl?
Yes.
Thank you. I vote yes. Motion passes. Okay, that was the only that was the only thing we had to cover today. So thank you all for participating, and we will now be terminating the WebEx to allow members to convene a closed session, except we won't have a closed session because we finished it yesterday. So thank you all, and we are now adjourned.
Thank you.